watching breaking news here on BloombergQuint. The Reserve Bank of India has decided to supersede the board of DHFL. The banking regulator, in a statement a short while ago, said that it had decided to supersede the board of DHFL on account of concerns around governance, but also the defaults that have taken place at DHFL. I'm going to read out the statement. This decision to supersede comes just a couple of days after the government finally put in place enabling provisions to allow financial services firms to go via a special window within the IBC. So the RBI, while saying that it is superseding the board of DHFL, added that it now intends to initiate the process of resolution of the company under the insolvency and liquidation proceedings of financial service providers, which is that special window that I'm essentially talking about. Now, just a very brief overview of why this has happened and how we have gotten to this point. The first defaults from DHFL happened in June, while lenders of DHFL have been trying to stitch together a resolution plan. It has been complicated by the fact that it has a number of creditors, including mutual fund holders and fixed deposit holders. So this special window has been created as an interim way out because we don't have a financial resolution law, a full one in place. Joining us to speak about some of the aspects of this is Ajay Shaw of DSK Legal, for starters. Ajay, thanks so much for taking the call. So this is clearly the first case which will test that special window that has been created under IBC for financial services providers.
That's correct. This will be the first case. In fact, this is pursuant to the rules which was, just notified recently.
Can you run us through what the process will look like based on what you have read from those rules? Because this is, as we just said, the first case.
So basically, unlike, a normal case of IBC where any creditor can approach the NCLT directly, in this particular case involving NBFCs, it will be the regulator, which is the Reserve Bank of India, who has to decide whether or not it wants to refer the matter to the NCLT under IBC. And once RBI takes that call, RBI will basically initiate the process of commencement of insolvency against the NBFC in the IBC. The other difference over here is that the moratorium will apply the moment they make an application, unlike other matters where on admission the moratorium kicks in. And the other process will basically be the same as what would have otherwise been applicable for a corporate debtor, save and except that in a situation of a resolution other than for a 29A compliance, that fit and proper test will be by the relevant regulator, which is the Reserve Bank of India in this case.
Right, Ajay. This is Vishwanath here joining in this conversation. You spoke about moratorium as well as the fit and proper, related norms that are there within this new part of the IBC. Just to get a sense of this moratorium period, this does not apply to, let's say, third-party assets or property, or including funds that are in securities.
It only applies with respect to the assets of the NBFC,
right,
and not otherwise.
Right. So, do depositors come under this window then?
Depositors, yes, because if the asset is of the NBFC, then they would technically fall within that.
Ajay, sorry, I'm just going to just ask you a couple of questions pertaining to the fact that, so far as the resolution process was going along, the problem was that mutual funds, etc., were, had their own set of issues and lenders and mutual funds couldn't agree. So now as it goes into this IBC process, there is a moratorium on all payments except for third-party assets, perhaps securitization assets. And the idea would be to quickly come in and get a buyer who can keep running this firm, or the administrator does that for a period of time?
That's correct. So basically what will happen is all third-party transactions, and specifically, after what transpired in the Mumbai High Court as regarding all receivable securitization transaction, that is completely out of the fold because that is not an asset owned by the DHFL or the NBFC. So that technically remains out of the purview. As regards the finding of a resolution is concerned, the resolution professional comes in. He will run the NBFC as a going concern, and with a moratorium with respect to its payout, and ultimately whatever is going to be the restructuring package which is going to be offered by a new bidder, that will be the way out of the insolvency.
Okay, and some of the cases that were going on, individual funds had filed. There was something in the Supreme Court yesterday. One of the fixed deposit holders had filed. All of those would have to get consolidated now under this particular proceeding?
That's correct. The multiplicity of proceedings which was otherwise there in context of every creditor trying to, recover the money from the NBFC or DHFL in this case, all that will cease or basically will be subject to moratorium, and the entire process will move to the bankruptcy court or the NCLT.
Right, Ajay. One last question from my side. Apart from, you mentioned this earlier, apart from this 29A limitation on whoever the bidder is, there's also this no objection that is required from the regulator with respect to fit and proper. Do you think that puts too much onus on because generally what we've seen in other insolvency cases is things tend to get dragged on because of multiple problems that are there within the law itself. But with respect to this specific requirement of fit and proper from the regulator, this no objection certificate from the regulator, do you think that could push the timelines further a little?
No, not really, because, in sensitive areas, and specifically when you're talking about NBFCs or certain national assets, there will be a situation where, certain kind of clearances which are otherwise required, because in addition to the 29A is more a disqualification. The parameters of the fit and proper person will be applicable. So I don't think, we can do away with it. As regards the timeline, it will be, we'll have to see how it pans out. But the intent is it's not to drag, but this can't be ignored.
Right.
All right, Mr. Shaw, thank you so much for joining us with those details. Just a reminder to our viewers that the story we are talking about is the fact that the Reserve Bank of India has superseded the board of DHFL. It will now proceed for resolution under the newly created window for financial service providers under the IBC. Sanjay Agarwal of Care Ratings joining us on the phone as well. Sanjay, how do you see this development? In some ways, it sort of puts an end to the uncertainty because so far it didn't look like the lenders were getting anywhere with getting a resolution plan in place.
Yeah, good evening, viewers. So this obviously is a good step ahead in terms of trying to consolidate the efforts of various parties and see how you can best protect public money and move ahead in the resolution of the whole DHFL crisis.
Sanjay, just want to ask you if you have a sense of, the idea is to keep this company going as a going concern while it's under this process. There'll be a moratorium on all payments except for third-party payments. But how do you keep it going as a going concern? Who's going to lend to it? How are they going to keep lending going? Is that feasible, or is that something that is, sort of we hope to do, but we're not clear whether it will be achieved?
So what I understand is no fresh investment is happening into DHFL right now. So it is the company receives repayment from the various borrowers which are there, and it repays the lenders to the extent it can. So that repayment has been happening over the period. So now obviously in the last few days there has been a moratorium and things have been at a standstill. But the company still continues to accrue funds from the from the borrowers, and the quality is pretty good, so funds are coming in. But there is no issue of new funds being deployed in the company or somebody lending fresh money. That's not happening.
Right. Sanjay, this is Vishwanath here. Just wanted to get a sense. I mean, you said that no fresh money is coming in, but this administrator who's going to come in and manage the affairs of the company for the time being, they'll still have to keep the ball rolling, at least keep the company as a going concern.
Yeah. So the money which is coming from especially from the retail borrowers, that is coming in, and that I think will be that is the amount of fund which will be there. So. And I assume that the process will entail, let's say, sale of assets or something, whatever has been discussed in the media over the time. I don't have knowledge of what exactly is happening, but given the media reports, some, let's say, a sale of assets or some division or something which could happen. Once that happens, probably more funds will come in. But the general flow of funds is there from the retail borrowers, and I think that continues to happen.
Sanjay, a question from the broader financial services sector viewpoint. We know that, of course, DHFL is not the only NBFC or HFC which is in default. This does sort of set a precedent, and in some ways gives a little bit more clarity that there is an option for the regulator, although they probably won't use it very commonly, to push for resolution if there is an issue at an NBFC.
So such incidents are not common to expect that, you can have a high profile or a large finance company having financial troubles to the extent which are there. So we don't expect that to be common as it is. But now at least there's an option with the regulator to take the process ahead and act quickly rather than asking all the stakeholders to get together and arrive at a conclusion.
All right, Mr. Agarwal, thank you so much for joining us. That's a quick take, one from the legal end and one coming in from the financial services industry and on DHFL. Vishwanath, anything you want to add? I think the only thing to talk about now, although early days, is what the resolution process will look like.
Yeah.
We know what had been proposed. Do you want to run us through that?
Yeah, so originally the proposal that is there, as in what the government had announced, was essentially that there's going to be a committee of creditors. There's also going to be a group of expert advisors that the regulator can set up for itself. Then of course the rest of the process goes as according to what the IBC talks about. You invite bidders, you essentially run the whole process. The lenders do their bid, that is to check whether this bidder is compliant with all the norms within the IBC, and of course the regulator on its part has to give a no objection certificate which says that this bidder is fit and proper, and then it goes through. Finally, the NCLT has to approve the bid as it does in most other insolvency cases.
Yeah, and I think what had been proposed by the lenders, it's possible that a similar plan would go through with some caveats from what we've heard, is that there would be the retail portion of DHFL's loan book, which will perhaps be sustainable and continue to be serviced. There will be the wholesale portion where there will be some restructuring involved, and some amount of that would be conversion of debt into equity. There was a case of what happens to the retail depositors, the FD holders, and I think what we have heard from some people in the know is that there would be a provision made to pay out those FDs when they mature. We don't know. This will all play out in court, but this is something that it seems the regulator has expressed an interest in.
Yes, because obviously the retail depositors are going to be the people who are going to be stuck. There's financial institutions otherwise. Typically, they are the ones who will be stuck with the process. So they will need that payout to come in as and when it's due.
All right, we're closing off this special programming on BloombergQuint. Do go to BloombergQuint.com. We've got all the details on this unusual move from the regulator on the website.